counsel is an attorney, I believe.
No, I was just going to switch to block in.
Mr. Chair, I would just request that we
Could
revisit.
you identify yourself?
Oh, absolutely. Lisa Holley, Holley, Providence, Rhode Island, attorney for Ken Block.
Sure.
Mr. Chair, I would just request an explanation as to why Mr. Block is being sworn in, as I perceive that this request for fee waiver does not encompass your quasi-judicial role. This is a member of the public just asking for a request of a fee waiver, something that in other APRA circumstances is done by letter. So I'm just questioning why he must be sworn in for a simple request of a fee waiver under the statute.
Mr. Chair?
Sure.
I've had some discussions with legal counsel about this, and the question becomes what constitutes counsel quasi-judicial role, and whether or not we're engaged in fact-finding. You would concede that if we're engaged in a fact-finding process, that would necessarily require some level of evidence that is sustainable on appeal.
I wouldn't concede that,
You wouldn't
Judge.
concede that?
I would not.
Okay.
I will give you
Why
my
not?
experience as 11 years as chair of the parole board, which is a documented quasi-judicial board. At no time did we ever have anybody appearing before the parole board, even in revocation hearings, swear an oath before the board. I believe that this is far extends past the request here today, and I have some serious concerns about why Mr. Block is being asked to take an oath before this board.
Why do you have concerns?
Because this is a simple request for a fee waiver, which is done often in APRA circumstances, and it seems strange to me that Mr. Block is being asked in a very ministerial request to be put on.
Why do you call it ministerial?
It is extremely ministerial. The APRA requests and waivers for requests are done routinely by mail. And he has been called to this board to provide statements as to why he's requesting this.
Counsel, we
and
didn't
he's
call
happy
him.
to do so.
We didn't call him to the board.
I believe he asked by mail, and he was then brought to the board at the last hearing.
We
And
didn't bring him to the board. He appeared voluntarily.
so can he be, his
I
request?
just want to make it clear on the record, we did not direct him to come here. He submitted a letter, he made a request.
And was the letter responded to, Judge?
We never had
Within the
it.
10 days that APRA dictates that a body will
We
respond?
put it on the very next agenda. As soon as we got the letter, we notified him that it was going to be before the board. We did not request a hearing. We did not request that he come before the board. We didn't make any of those requests.
So that being said, why is there a need for him to testify today? Can we sit and hear the board's decision? I've submitted a letter which provides specific factors for consideration of fee waivers.
But the fact of the matter is, I think we should hear from counsel. I just wanted to correct the record that we didn't direct him to be here. We didn't ask him to be here. He submitted a letter.
So noted, Judge.
Okay.
I've heard that.
Okay.
My recommendation would be to hear from Ms. Holly, listen to what she has to say, and then if the board believes that it has some need to develop a factual predicate for its decision, we could then revisit that issue. That would be my recommendation.
I'm comfortable with that.
Thank you. May we be seated?
Always.
I've submitted a letter to Chairman Dubois, which sets out some factors. As you know, the APRA, which is Rhode Island's Public Record Act, is somewhat devoid of case law. And although we are looking at this issue under Rhode Island APRA, it's well known that APRA has been somewhat maybe mirrors the FOIA, the Federal Freedom of Information Act. So when an analysis is made of APRA, oftentimes both the Attorney General's office and agencies look to FOIA-related cases. So in my research to represent Mr. Block, I looked at other cases where fee requests have been analyzed to determine what should the board look for when a member of the public comes before you and asks for a fee waiver. And although section 3824 actually provides you the guidance, which states that if the information requested is in the public interest, because it is likely to contribute significantly to public understanding of the operations or activities of the government, and is not primarily in the commercial interest of the requester, I also did some research to provide you with some of the factors when a judge is looking at an appellate review of a fee waiver. And FOIA sets out these factors which are in my letter. These factors, if you'd like me to state them for you, I don't want to take your time, they're before you, but I'm happy to put them on the record if you so choose, and I'll defer to the chair if you would like me to do so.
Well, before you decide on that, my question, Ms. Holly, is you've cited a good part of 3824 subsection E, but you leave out that first reference to a court. Is it your view that an agency such as the board needs to consider a request for a waiver?
That's correct. My next sentence says agencies may also take the above factors in consideration when evaluating fee waiver requests. Clearly, that language is in there to guide the court in what they would do if we were to appeal this to a court. And obviously, Attorney Mercantio is aware that we have appellate steps to take both to the Attorney General's office and as well to the Superior Court. We're hoping that's not the case here because we believe when you look at the factors that are set out in the FOIA cases, and many states actually with their APRA rules, when they promulgate the rules, they also state these FOIA factors as well for fee waiver.
Is it your position that for Mr. Block to make this request, he must first do so here?
Yes, absolutely. The first request goes to the agency, not to a court.
And that's based upon, do you have case law from the Attorney General to that effect?
I do not. I do have case law where the Attorney General does reference in a footnote that the person did not request from the agency, but it would have been taken into consideration had he done so. I do have that, and we'll give it to you if you
Counsel, if
so
I could
choose.
just follow up on one thing. You were involved in the state police APRA, correct?
Yes, I was.
Well, I just read this APRA rules for the state police, and they don't have anything about a waiver.
They do not, but we routinely granted them.
Okay, so you wrote rules that had no waiver provision in it at all. Now we have similar rules, which you want us to waive.
I don't see where that's relevant, sir. I mean, the instant issue is a waiver by a member of the public for the public interest. I think that's what should be considered, not what happened in 2007.
I'm reading the state police regulation that you indicate that you were involved in. It says section 8 fees, subsection E. If a court determines the information requested is in the public interest, it may reduce or waive fees for search and retrieval costs, and I think that's what counsel was getting to.
That's correct. That's verbatim from the
I think
statute.
that an agency maintains the discretion to do so. The statutory language refers to the jurisdiction of a court to do so. So you have, in my opinion, you do have discretion, but I believe there are decisions from the Attorney General that support the position that in the first instance this could also be heard by the court. That's entirely up to you. We just implemented a policy. The policy does not have any reduction language in it. The policy essentially relies upon the first part of 3824, which speaks to providing some relief for the requester, namely the first hour being free. So the General Assembly has provided some guidance to the agencies as to what we have to do to make sure that there's a balancing of interest between what the public wants and what the state needs for compensating its costs. That being said, you certainly still maintain the discretion to hear it if you want to and to provide relief.
I have a couple more questions for council. Are you aware of the extent of the time and effort that staff has put in to Mr. Block's request over the past year?
I am, over the past year,
Yes.
I am only aware of the extent to which they
So-
put into this particular
If I told
instance.
you there was over 100 and perhaps as many as 200 hours spent responding by our very small staff to Mr. Block's requests, would that impact your argument in any way?
I don't believe so, sir. I think, we all struggled when APRA came to be and when the Secretary of State's office mandated that each agency promulgate rules for APRA, each agency have a designated APRA custodian. I think we all had the same feeling like, how in the world are we ever going to respond to these requests? They're going to be voluminous. We'd have to hire staff. And I think at the end of the day, both the AG and the Secretary of State's guidance was, this is about open, transparent government. This is about the public being able to see how their government does business. And you have to do it however you can, whether or not there's a strain on staff at all. That's not part of the balancing test, how it impacts the agency. It's whether or not the public has a right to know what their government is doing. And unfortunately, it does put a strain on agencies and overburden agencies, I'm sorry to say.
Are you aware of the extent of this request?
I am aware of this request, yes.
That it goes back to 2003?
I am aware of this request and what the request entails.
Which seems to be more historical than it does with respect to current issues concerning the board, since it goes back to a time of a prior regulation, prior board, prior executive director. How does that serve the public interest?
Again, I think it is looking at how a particular agency does its business, whether it's over a certain time period or if it's contemporaneous. I don't think that the act has any lens for when or how or the longitude of the request.
Ms. Holly, with the request that Mr. Block made in mind, can you share with the board how that specific request, as it says, contributes significantly to the public understanding of the operations or activities of the government?
Yes, indeed, because the request absolutely goes to that. It goes to the communications between the Board of Elections and each individual city and town and their communications on how elections are conducted, how voters are registered. I mean, this goes to the very crux of democracy and elections.
Well, you've seen the documents.
I have not seen the documents. My review is not to look at documents. That's not my purpose
Well, isn't
here.
that critical to make a determination that what's being requested is contributing significantly to the public understanding? Don't you have to have at least what's your understanding as to how that criteria, assuming that this board were to assess that criteria by the statute, what is it that was requested and provided that would satisfy that language? Obviously, you've said that it goes to communications, I understand that, but after those communications have been examined, how does the disclosure of that contribute significantly to public understanding of the operations of the board?
Well, I would dare say that how the board communicates with the locals as to the very issue of elections and voter registration is paramount to what the Board of Elections does. The very existence and the very purpose of the Board of Elections in running free and certainly valid elections.
These emails that have been provided to Mr. Block, in your view, have met that criteria that's set forth in the statute, and if so, how?
It meets, well, frankly, I can't address all these issues, and I feel like I'm probably not the one that can provide the factual basis of what you're asking.
Wouldn't a court be asking you that very question?
Yes.
Frankly, again, I'm going to object to the fact that we're here with a public request for a waiver. This is not a court. There shouldn't be a colloquy where I am here to put facts on the record. So what in essence is happening is there's a shifting here, so, Mr. Block is not being sworn in and made to testify, but you're asking his legal counsel to testify to facts that I don't have.
I'm not, I'm asking you to meet the language contained in the statute. That's what
And the
I'm asking you.
language contained in the statute says, it's a public interest because it's likely to contribute significantly to public understanding of the operations of government. You're asking me for granular facts about what is in the emails that Mr. Block has requested. That's not the inquiry here. The inquiry is, how does government do its business?
If I might just intervene for a second. Since you haven't read the emails, how can you make an argument that they're in the public interest and therefore should have the fee waived? It seems like you're missing the essential predicate for making the argument. In fact, Mr. Block's request was not for the current operations of government, not even for recent operations of government, which we gave him, but for the historical process of communications that took place in a far distant time and in a far distant way. So it seems to me that the amount that's requested here, the information that's requested going back to 2003, is not something that's in such a pressing public interest. Rather, it looks like it's a historical research, and we adopted a policy, and this is the first. We adopted that policy because, among other reasons, we should have a policy, number one. And number two, we had a situation involving people that made a request that cost a significant amount of time and energy, and we didn't ask for any money up front, and they've never paid for it. And so the state is out the money. So we looked at that and we said, no, we've been doing things the wrong way. We should do it the way it says in the statute. And I know the state police charges in many instances, and I know all these other departments that you've been engaged with charge for open records requests. We've got an individual who we're asking for him to pay for one request out of the hundreds of hours that he's spent engaged with board time. It doesn't seem unreasonable that we simply continue to implement the policy we have and to allow a court to make that decision as the statute provides for. Why is that unreasonable?
If that's the board's decision, that's the board's decision. I just question whether or not we were asking for records that were contemporaneous if we'd be going through this again. You keep going back to it's a 2003 records that he's asking for. I don't think the statute presupposes what the person is looking for and what the time frame is. There's a particular purpose that Mr. Block is looking for these records, and I don't think the statute says it's only for records for the last 2 years. Frankly, I believe he could ask you for records from 1998, and it would still be subject to the Access to Public Records Act, and you would still either have to grant them or deny them without any consideration as to the time, and also the fact that, it takes some computer process to try to extract these records.
Right, but you keep stressing the public's interest. The public's real interest here is for us to run a good election. And if you keep diverting our resources and our staff to do, like what the designer said, historical research, I understand, we'll get to it. But we can't divert staff, time, resources for that. The main purpose is to run an election, and you want to interact with the locals. If we don't run a good election, they'll be interacting with us. That's what
I understand that, sir.
That's what I'm saying. Our main function here is to run elections.
Absolutely,
We
but
accommodate people as our resources allow us to.
Absolutely.
But you just can't keep one a week. I mean, this is,
So I'm hearing a few
Counsel,
things, and
Can I
I'm
just interject one
Sure.
thing? I got a printout of all the emails back and forth between staff and your client.
yes.
It was about 600 pages for the past year.
Yes.
Okay, so all of that was provided without cost. all that information. He's asked us to drill down with individual cases involving what he perceived to be duplicate voting, which turned out not to be the case, and other issues that turned out not to be the case. We've had back and forth between Mr. Block and Mr. Raposa, back and forth on the same individual, and a huge amount of staff time has been provided gratis to Mr. Block. Now we're looking at an actual APRA request, and the statute says we can charge. The regs say we can charge. The statute says we can charge, and that the court makes a determination as to whether or not it's in the public interest. So why should we, in the very first request that's made under our new policy, ignore the policy? How is this different from any other case that would then be before us?
So I'm not asking that you ignore the policy, I'm asking that you also look at the fee waiver section of the statute. But I guess my question is, had Mr. Block not asked previously for other things, would the board be taking the same posture? Is it just that this one's enough? And if that's the case, then so be it, and let us know that. But I think each one, other than what the statute defines as a continuing request, each request really needs to be taken as a standalone, unless it's a continuing
I agree with that.
request.
But this is the first request we've had. Mr. Block was actually present at the board meeting where the board adopted the policy. He was silent when it came to the question of adopting the policy. So he was here when the policy was adopted. He had no objection to the policy. We gave him fair warning that we were implementing the policy, and we were implementing the policy. And it seems to me that we can't, if we waive the first request, I don't know how we'd ever, I don't know how this request in any significant way varies from any other request that any other individual would make for information. And so if we grant this one, then we have to grant all the waivers.
No, I believe you don't have to grant every waiver. I think the factors that I provided in my letter give you guidance as to when you would consider a fee waiver. Mr. Block tells me that he did indeed object at that point to a fee waiver, but I think...
Not before the record, not before the board at the time that the regular policy was adopted. I don't recall that.
He states that he did, but I would also argue that that really has no bearing here, because John Q. Public, who wasn't at the meeting, wasn't here when you were promulgating these rules, didn't have the opportunity to object, and then next month comes before you. You can't use that same argument that they never objected to a fee waiver when you promulgated rules.
I'd love to listen to that tape, because I don't think there was a formal objection by Mr. Block to that policy when it was adopted.
Mr. Chairman, I would move that we deny the request for a waiver.
I'll second that.
There's a motion on the floor by Commissioner Pierce and seconded by Judge Erickson to deny the waiver. All those in favor?
Aye.
Aye. All those opposed? One. Patty, you have that?
One more issue as to that, it's subsequent to that. Mr. Block had asked for a detailed itemization of what the fees are. We believe that some of the fees may be unreasonable, and we would ask that the board provides that. The statute allows for an itemization of the fees, and that all fees be reasonable. We've learned from the process that although we asked for the fees to be electronically transferred, they were actually printed out, then scanned, and then provided, which would add extra steps to print out as opposed to send electronic. The statute allows for records to be provided in the manner which they were requested, and that was not done, so we believe the fee is about double what it should be due to the fact that there were copying costs that were unreasonable, as well as time spent printing, copying, scanning. So we would like an itemization of what the fee is.
Mr. Chair, I think we provided that, didn't we? Yeah, we did. There's a letter.
We did via an email.
We did send an email.
There was a meeting scheduled yesterday that was canceled to go over the fees.
We did.
Mr. Reboza was there.
There was a meeting that was scheduled for yesterday. We have an itemized, so we did send an itemized breakdown on January 10th, which is part of your package.
You're talking about really granular stuff, Counsel. You know, the other day I got a call from somebody about one of the mental health issues I work on, and they wanted to send me a fax. And I said, who uses faxes anymore? I had to go to disconnect my phone and hook it up to the printer and so forth. And, you know, they might as well have asked me by telegraph, you know. But the fact is, that's the process we used, and it's a reasonable process. And we gave you the information.
Well,
It's not very much. It's
I'm
only.
just-
Can we move to the next item?
Yeah, okay.
And discussion, so. Thank you. Number 4, the board may vote to certify the mail ballots for the Situate special election.